government shutdown. U.S. District Judge Susan Ilston in California has issued the order after unions representing federal employees argued that the planned job cuts were politically motivated and unlawful during the funding lapse. The ruling came in response to the administration's plan to cut more than 10,000 jobs following White House Budget Director Russell Vought's remarks and President Trump's statements targeting Democrat agencies. The administration had already issued layoff notices to over 4,100 workers across departments, including Treasury and Health, as well as Human Services. Judge Ilston's order temporarily halts the firings and demands that the administration justifies its actions, noting that using the shutdown to downsize government outside legal procedures is improper. Meanwhile, the U.S. Treasury has warned that the ongoing government shutdown could cost the economy $15 billion a week, highlighting the urgent need for resolution. Now, for this discussion, we're joined by Matthew Vadam. He's an American journalist, joins us live from Washington, D.C. Thank you, Matthew, for joining us again. Good to see you. Matthew, what legal precedent does this Judge Ilston's ruling set regarding executive authority during this shutdown, especially when it comes to workforce reductions?
I think she's on very thin. Legal ground. The courts can't normally force the government to spend money, except in very narrowly defined circumstances. So I expect that the Trump administration will appeal, and they may be successful. If President Donald Trump doesn't have any money authorized by Congress to pay employees, what is he supposed to do? The court cannot force him to borrow money to pay these people. At least it's not my understanding that he can. So I'm sure that the Trump administration will abide by the court ruling for the time being, but I'm sure that they're already planning an appeal. I wouldn't be surprised if one would be filed today, because they put the federal government the Trump administration in an impossible position. People had to be laid off or furloughed, government workers, because there is no legal authorization to pay them. And now the court is saying, well, despite having no legal authorization to pay them, you have to keep them on staff. And I don't think the courts can do that, and I think it will be overturned. But I'm sure the Trump administration will abide by the court order for the time being.
And what are the potential long-term consequences for federal agencies like Treasury and Health, Human Services if these jobs were to be cut?
Well, probably good for the American people, because the bigger the government is, the worse off it is for the people of the United States. These federal agencies are top-heavy. They have too many employees as it is. I'm sure that the unions will complain and say that there aren't enough people, but that's just self-serving talk. There's no reason why they can't cut a lot of federal government jobs, and the Democrats' repeated votes against funding the government have given President Trump an unprecedented opportunity to fire federal government employees. So if the Democrats wanted to protect the federal workers they claim to care so much about, then they should have voted to keep the federal government open to continue funding. But they didn't. And this is what happens when the government doesn't have any legal authority to pay its employees. They get laid off, and some of them get fired. And I don't think anything can be done about it, and I don't think it's necessarily a bad thing.
Thank you, Matthew, for sharing that insight. Please stay with us. Now we stay in U.S. Dozens of journalists covering the U.S. Defense Department have vacated their offices inside of the Pentagon and returned their press credentials after refusing to comply with new access restrictions. The Defense Department has set a Tuesday deadline requiring news organizations to sign a new Pentagon access policy or lose their credentials and workplace access as well. At least 30 news outlets declined to sign the policy, citing concerns that it threatens press freedom and hampers independent reporting on the nation's military. The new rules require journalists to acknowledge that they could be labeled security risks and have their press badges revoked if they seek classified or certain unclassified information from Pentagon employees. The Pentagon Press Association, representing over 100 news organizations, called Wednesday a dark day for press freedom and criticized the policy for undermining transparency and public accountability. Pentagon spokesperson Sean Purnell has defended this policy, saying it is necessary to protect troops and national security, and disputed claims that reporters were being unfairly targeted. Journalists have described the Pentagon press area as unusually quiet as they removed furniture, equipment, and other materials. Veteran correspondent J.J. Green of WTOP has remarked on the unprecedented silence in a typically bustling workplace. Traditionally, Pentagon press badges, which require background checks, allow reporters access to unclassified areas in close proximity to Defense Department spokesperson. Television outlets have until Friday to remove their equipment. Now we go back to Matthew Vadam. He's an American journalist, joins us live from Washington. Matthew, since you're also a journalist and you are in states as well, so how did these new Pentagon access rules alter the traditional relationship between press and U.S. military? And what was your reaction when you saw this news?
My initial reaction is that it seemed like an overreach by the Department of Defense, now known as the Trump administration calls it the Department of War. And I think the Pentagon is overreaching. They're concerned about whatever they're concerned about, leaks, unauthorized leaks of information and so on. But journalists have had access to people in the Pentagon. The new rule says that they can't, wander around the Pentagon anymore and just talk to people that they find there. Whereas before, except for a few areas that were off limit, as I understand it, they had liberty to wander around the Pentagon building and talk to soldiers and to Marines and sailors and so on that work there. And this freedom has been taken away. And talking to people is how journalists report the news. That's how they get stories. So if they're not allowed to do that, that means what are they going to do? Are they only going to report authorized press releases from the government? That's not really, no self-respecting journalistic organization, news organization is going to do that. And that is why, with the exception of, I think, just one TV network, conservative One America News Network, I believe, was the one that did not surrender its media credentials. Nobody is going to agree to that, because that's just saying you can't do journalism. And that means that the stories, there's not going to be as much news, not as much interesting news coming out of the Pentagon. The media organizations that have
Yes.
said they won't comply with the policy and have surrendered their media passes can still report on what's going on at the Department of Defense or War, and it just means they won't have access to personnel in the building anymore,
Thank you.
which which seems like a real shame. It seems like a real hindrance. It prevents them from doing their job properly.
Thank you very much, Matthew, for sharing that insight as an American journalist. Now we stay in U.S. The U.S. Supreme Court's conservatives signaled that their willingness to undercut another key section of the Voting Rights Act, the landmark 1965 federal law enacted by Congress to prevent racial discrimination in voting. The questions they posed during the arguments in a major case involving Louisiana electoral districts reflected an interest in curbing the Voting Rights Act's Section 2, which bars voting maps that would result in diluting the clout of minorities, even without direct proof of racist intent. The court, with its 6-3 conservative majority, has moved American law dramatically rightward in the recent years. The Republicans currently hold a slim majority in the U.S. House of Representatives, and a decision gutting Section 2 could benefit them. Now for this discussion, we are joined by Matthew Vadam. He's an American journalist, and Raymond Vickery. He's a former U.S. Assistant Secretary of Commerce, both joining us live from Washington. Thank you to both our guests for joining us. Good to see you. Raymond, I would like to come to you first. What are the broader implications might this potential ruling have for minority political representation and the balance of power in future congressional elections?
Well, thanks very much for having me. It's a very serious attack on the progress which was made over the last half century in the United States. Up until the Voting Rights Act of 1965, systematically, particularly in the South, the powers there, the elected officials, excluded blacks from voting by a variety of means, and one of which was, of course, gerrymandering, so that the power of the vote really was taken away in conjunction with other things, such as literacy requirements or even poll taxes in some states. So in 1965, this was a landmark achievement of the United States. Lyndon Johnson had picked up the banner from John Kennedy, and this happened. Unfortunately, what is going on in the United States is a retrogression, that we are going backwards rather than forwards in terms of enforcing human and civil rights, particularly for the disadvantaged parts of our population, namely African Americans, who were enslaved for centuries in this country and have suffered the aftermath of that enslavement and discrimination up until there was progress in the mid 1960s. So this is really, though, a part of the entire Trump MAGA approach to try to eliminate voting powers or at least reduce them for minorities. It doubtlessly will favor the MAGA Republican candidates if this requirement of the Civil Rights Act is done away with, as the Supreme Court has already done away with others. It parades under the banner of treating those of disparate races completely equal, but what it does is disregard the entire history and social construct which has given a detriment to the principles of our Declaration of Independence, that all men are created equal and endowed by their Creator with certain inalienable rights, and this is just one way to restrict those rights.
Building on that answer, Matthew, I would like to come to you now. How could this decision by Supreme Court weakening Section 2 reshape electoral politics, particularly in closely contested states such as Louisiana?
Well, it likely would mean that the Republican-controlled legislature of Louisiana would eliminate the two protected seats for Democrats, um, and likely Republicans would win those seats. The issue before the court was whether race-based redistricting violates the Constitution, particularly the 14th and 15th Amendments. And having covered the argument at the Supreme Court yesterday, it seems pretty clear that the Supreme Court is going to take action. I don't know if they're going to strike down the practice of race-based redistricting, but they're definitely going to apply some kind of curbs to it. The argument by Louisiana and by the United States government, which also joined, was also present and arguing at the hearing yesterday, was that the voting rights, Section 2 of the Voting Rights Act was created to forbid discrimination in voting practices for with respect to race, but that over the years it has been misinterpreted by the courts to require discrimination in favor of those specific groups. And so their argument, Louisiana and the argument of the United States yesterday, was that race-based redistricting is repugnant to the Constitution and it needs to be done away with. And it's interesting because they first heard an oral argument in this case a few months ago when the focus was narrower. It was just on, the Voting Rights Act and so on, and the redistricting itself. Then they changed it a few months ago. The court declined to come to a decision. I guess they weren't happy with the argument, or perhaps the justices could not reach agreement on what they wanted to do, so they ordered a re-argument of the case, which took place yesterday, and that's the gist of it. One side, Louisiana and the U.S. said that we should not allow legislatures in the states to redistrict on the basis of race anymore, and then the other side said, well, this isn't fair. Minorities have been treated unfairly, especially by states like Louisiana. They used to have a poll tax and restrictions on voting that adversely affected, black and minority voters, and that they still need protection. And this was the clash yesterday. And my guess is that the Supreme Court is going to, I don't know if they're going to strike down Section 2 of the Voting Rights Act as unconstitutional as some pundits have been suggesting, but I think they are going to at least place some restrictions on it because there was clear hostility to, not to the Voting Rights Act at the Supreme Court, but to the way it has been interpreted since it became law in 1965. The Supreme Court justices seem to be saying that the lower courts have lost their way and that this law has been interpreted the wrong way, and we need to get back to basics. And as Chief Justice John Roberts said in another case a few years ago, the way that we stop discriminating on the basis of race is we stop discriminating on the basis of race. So he's often squishy and isn't solidly on the side of conservatives or being a strict constitutionalist a lot of the time. But it sounds to me like he's on board with this move to rein in race-based redistricting. So
Right.
I think we're going to see it happen. But I can't promise